All right, hello everyone. I'm Leonard French, your favorite copyright attorney, and today we have the 8-1 Supreme Court decision ruling that the cheerleader wins in the F-cheer case. This was a case that has been winding its way through the appeals courts, and the school really wants to have the power to discipline the student, even for things they say off campus. And the lower courts have firmly sided with the students' free speech. Really interesting. I literally took a continuing education course on this case yesterday, and we were eagerly awaiting this decision, and then it drops today. The court, Justice Breyer, does a really great job of explaining everything, so instead of me going into all the jurisprudence and the case law and all that, let's just take a look at what the court has to say. This is in the Supreme Court of the United States. This is Mahoney Area School District versus BL and her father and mother, Lawrence Levy and Betty Lou Levy. Justice Breyer delivered the 8-1 opinion of the court, and he writes, a public high school student used and transmitted to her Snapchat friends vulgar language and gestures criticizing both school and the school's cheerleading team. The student's speech took place outside of school hours and away from the school's campus. Those are key facts here. In response, the school suspended the student for a year from the cheerleading team. We must decide whether the Court of Appeals for the Third Circuit correctly held that the school's decision violated the First Amendment. Although we do not agree with the reasoning of the Third Circuit panel's majority, we do agree with its conclusion that the school's disciplinary action violated the First Amendment. BL, who together with her parents is a respondent in this case, was a student at Mahoney Area High School, a public school in Mahoney City in Pennsylvania. At the end of her freshman year, BL tried out for a position on the school's varsity cheerleading squad and for right fielder on a private softball team. She did not make the varsity cheerleading team or get her preferred softball position, but she was offered a spot on the cheerleading squad's junior varsity team. BL did not accept the coach's decision with good grace, particularly because the squad coaches had placed an entering freshman on the varsity team. That weekend, BL and her friend visited the Cocoa Hut, a local convenience store. There, BL used her smartphone to post 2 photos on Snapchat, a social media application that allows users to post photos and videos that disappear after a set period of time. BL posted the images to her Snapchat story, a feature of the application that allows any person in the user's friend group, BL had about 250 friends, to view the images for about 24 hours. The first image BL posted showed BL and a friend with middle fingers raised, and it bore the caption, F school, F softball, F cheer, F everything. The second image was blank, but for a caption which read, love how me and another student get told we need a year of JV before we make varsity, but that doesn't matter to anyone else. The caption also contained an upside-down smiley face emoji. She was sad. BL's Snapchat friends included other Mahoney area school district students, some of whom also belonged to the cheerleading squad. At least one of them, using a separate cell phone, took pictures of BL's posts and shared them with other members of the cheerleading squad. One of the students who received these photos showed them to her mother, who was a cheerleading squad coach, and the images spread. That week, several cheerleaders and other students approached the cheerleading coaches, visibly upset about BL's posts. Questions about the posts persisted during an algebra class taught by one of the 2 coaches. After discussing the matter with the school principal, the coaches decided that because the posts used profanity in connection with a school extracurricular activity, they violated team and school rules. As a result, the coaches suspended BL from the junior varsity cheerleading squad for the upcoming year. BL's subsequent apologies did not move school officials. The school's athletic director, principal, superintendent, and school board all affirmed BL's suspension from the team. In response, BL, together with her parents, filed this lawsuit in federal district court. The district court found in BL's favor. It first granted a temporary restraining order and a preliminary injunction ordering the school to reinstate BL to the cheerleading team. In granting BL's subsequent motion for summary judgment, the district court found that BL's Snapchats had not caused substantial disruption at the school. So it has to cause substantial disruption at the school, and that is from Tinker v. Des Moines Independent Community School District, which is a very famous 1969 Supreme Court free speech case. Basically, schools that operate as an arm of the government, so we're not talking about private schools, we're talking about public schools, students have less free speech rights or fewer free speech rights than adults do against the government, but they still have them. And this case is about where that line is for these particular facts. Consequently, the district court declared that BL's punishment violated the First Amendment, and it awarded BL nominal damages, which means almost nothing. And, could be $1, could be $100, could something that isn't millions of dollars or hundreds of thousands of dollars, or probably not even a 4 or 5 digit sum, and attorney's fees, and ordered the school to expunge her disciplinary record. On appeal, a panel of the Third Circuit affirmed the district court's conclusion. So they agreed. In doing so, the majority noted that this court had previously held in Tinker that a public high school could not constitutionally prohibit a peaceful student political demonstration consisting of pure speech on school property during the school day. In reaching its conclusion in Tinker, this court emphasized that there was no evidence the student protest would substantially interfere with the work of the school or impinge upon the rights of other students. You're going to see more about that substantial disruption or material disruption in this case. That's defining the standard for when a school can infringe upon the free speech rights of a student. But the court also said that conduct by a student in class or out, which for any reason, whether it stems from time, place, or type of behavior, materially disrupts classwork or involves substantial disorder or invasion of the rights of others, is not immunized by the constitutional guarantee of freedom of speech. That's the lower court. Many courts have taken this statement as setting a standard that allows schools considerable freedom on campus to discipline students for conduct that the First Amendment might otherwise protect. But here, the panel majority held that this additional freedom did not apply to off-campus speech, which it defined as speech that is outside of school-owned, operated, or supervised channels, and that is not reasonably interpreted as bearing the school's imprimatur. Bearing the school's imprimatur would mean if the school was the sponsor of it, like a school-sponsored newspaper. So if it's not, the school newspaper, then it doesn't bear the school's imprimatur, if it doesn't say it's from the school. Because BL's speech took place off campus, the panel concluded that the Tinker standard did not apply, and the school consequently could not discipline BL for engaging in a form of pure speech. A concurring member of the Third Circuit panel agreed with the majority's result, but wrote that the school had not sufficiently justified disciplining BL because, whether the Tinker standard did or did not apply, BL's speech was not substantially disruptive. The school district filed a petition for certiorari to the Supreme Court, asking us to decide whether Tinker, which holds that public school officials may regulate speech that would materially and substantially disrupt the work and discipline of the school, applies to student speech that occurs off campus. We granted the petition. We have made clear that students do not shed their constitutional rights to the freedom of speech or expression, even at the schoolhouse gate. Minors are entitled to a significant measure of First Amendment protection from Brown v. Entertainment Merchants Association, but we have also made clear that courts must apply the First Amendment in light of the special characteristics of the school environment. One such characteristic which we have stressed is the fact that schools at times stand in loco parentis, in the place of parents. This school has previously outlined 3 specific categories of student speech that schools may regulate in certain circumstances. So these are the permissible regulations. 1. Indecent, lewd, or vulgar speech uttered during a school assembly on school grounds. 2. Speech uttered during a class trip that promotes illegal drug use. And 3. Speech that others may reasonably perceive as bearing the imprimatur of the school, such as appearing in the school-sponsored newspaper. Finally, in Tinker, we said that schools have a special interest in regulating speech that materially disrupts classwork or involves substantial disorder or invasion of the rights of others. These special characteristics call for special leeway when schools regulate speech that occurs under its supervision. Unlike the Third Circuit, we do not believe the special characteristics that give schools additional license to regulate student speech always disappear when a school regulates speech that takes place off campus. The school's regulatory interests remain significant in some off-campus circumstances. The parties' briefs and those of the amici, the friends of the court, list several types of off-campus behavior that may call for school intervention or regulation. These include serious or severe bullying or harassment targeting particular individuals, threats aimed at teachers or other students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other school activities, and breaches of school security devices, including material maintained within school computers. Even BL herself and the amici supporting her would redefine the Third Circuit's off-campus, on-campus distinction, treating as on-campus all times when the school is responsible for the student, the school's immediate surroundings, travel en route to and from school, all speech taking place over school-owned laptops or on a school's website, speech taking place during remote learning. That's a big one. We've had this question a lot in the past year. When is the school allowed to regulate what happens during remote learning? I think there were a couple cases where students showed a plastic knife or a toy gun, and the school disciplined them as if the student had brought a plastic knife or toy gun to school, which we can argue all day whether that's right or wrong, but the question was whether the school had any legal basis to do so. The Supreme Court I'm not sure if this is binding, but these arguments were made in favor of the plaintiff BL, that the school could regulate speech taking place during remote learning, including activities taken for school credit and communications to school email accounts or phones. And it may be that speech may be that speech related to extracurricular activities would also receive special treatment under BL's proposed rule. We are uncertain as to the length or content of any such list of appropriate exceptions or carve-outs to the Third Circuit majority's rule. So the Supreme Court, who usually likes to make these things pretty narrow, seems to be keeping it narrow. Of course, we still have a couple pages to go, but it seems like that list that I just rattled off isn't really part of the precedent of the ruling. That rule, basically, if not entirely, would deny the off-campus applicability of Tinker's highly general statement about the nature of a school's special interests. Particularly, given the advent of computer-based learning, we hesitate to determine precisely which of many school-related off-campus activities belong on such a list. So if you're talking about the student who showed the knife or the gun on a remote learning session during public school, you're going to have to bring this case and see what the Supreme Court says about a specific case. Neither do we know. We, the Supreme Court, do not know how such a list might vary depending upon a student's age, the nature of the school's off-campus activity, or the impact upon the school itself. Thus, we do not now set forth a broad, highly general First Amendment rule stating just what counts as off-campus speech, and whether or how ordinary First Amendment standards must give way off-campus to a school's special need to prevent substantial disruption of learning-related activities or the protection of those who make up a school community. So the Supreme Court is punting the can down the road. They are not broadly ruling on speech issues related to remote learning, et cetera, et cetera, et cetera. They're going to define a narrow rule that applies to this case and cases that fall within that narrow band of facts like this case. We can, however, mention 3 features of off-campus speech that often, if not always, distinguish schools' efforts to regulate speech from their efforts to regulate on-campus speech. Those features diminish the strength of the unique educational characteristics that might call for First Amendment leeway. First, a school in relation to off-campus speech will rarely stand in loco parentis, will rarely stand in the place of a parent. The school is not the parent. The doctrine of in loco parentis treats school administrators as standing in the place of students' parents under circumstances where the children's actual parents cannot protect, guide, and discipline them. So it's not that the school has the place of a parent when it has supervision of them. It's when the actual parents cannot protect, guide, and discipline them. So yeah, there's some overlap there, but generally speaking, the parents will be able to protect, guide, and discipline them. But when they cannot protect, guide, or discipline their students, their children, then the school may have the in loco parentis standing. Geographically speaking, off-campus speech will normally fall within the zone of parental rather than school-related responsibility. So on school, when the parents cannot be available, the school does stand in loco parentis. Second, from the student speaker's perspective, regulations of off-campus speech, when coupled with regulations of on-campus speech, include all speech that a student utters during the full 24-hour day. That means courts must be more skeptical of a school's efforts to regulate off-campus speech, for doing so may mean the student cannot engage in that kind of speech at all. So if the school was able to regulate a student's speech off campus, then the student would never have a time when they were allowed to speak themselves freely, or were allowed to express themselves within their First Amendment rights. The student would never be allowed to, really. There would never be a time when the school couldn't say, oh, you said this thing about cheerleading squad, and we can now regulate that. It's one thing if a private entity like like a private football league or soccer league or cheerleading squad for, adults for an adult football game or something. Yeah, you can regulate that all day. Your employer can regulate your speech as long as your employer is not the government, a public employer. Real quick, when we say designated public forum, we're talking about a forum that is owned by the government, not a private entity. We're not talking about when you are in public. We're talking about private versus public ownership, government versus private ownership. When it comes to political or religious speech that occurs outside school or a school program or activity, the school will have a heavy burden to justify intervention. Third, the school itself has an interest in protecting a student's unpopular expression, especially when the expression takes place off campus. So the school itself has an interest in protecting unpopular expression. America's public schools are nurseries of democracy. Our representative democracy only works if we protect the marketplace of ideas. This free exchange facilitates an informed public opinion which, when transmitted to lawmakers, helps produce laws that reflect the people's will. That protection must include the protection of unpopular ideas. Popular ideas have less need for protection. Thus, schools have a strong interest in ensuring that future generations understand the workings, in practice, of the well-known aphorism, "I disapprove of what you say, but I will defend to the death your right to say it," a quote that is often attributed to Voltaire, but is likely coined by an English writer, Evelyn Beatrice Hall. Given the many different kinds of off-campus speech, the different potential school-related and circumstance-specific justifications, and the differing extent to which those justifications may call for First Amendment leeway, we can, as a general matter, say little more than this. Taken together, those three features of much off-campus speech mean that the leeway of the First Amendment grants to schools in light of their special characteristics is diminished. We leave for future cases to decide where, when, and how these features mean the speaker's off-campus location will make the critical difference. This case can provide but one example. Considering BL's speech, putting aside the vulgar language, the listener would hear criticism of the team's coaches, and the school. In a word or two, criticism of the rules of a community in which BL forms a part. And we all know from copyright law that criticism is a very, very protected part of your First Amendment rights. Fair use in copyright, which I often cover copyright cases. Fair use in copyright is the codification of the First Amendment right in copyright. And criticism is at the core of fair use. Here, criticism is at the core of BL's freedom of speech. This criticism did not involve features that would place it outside the First Amendment's ordinary protection. BL's posts, while crude, did not amount to fighting words, so we don't have the fighting words exception. Real quick, my brief summary of the fighting words exception is if I yell, "Hey buddy, I'm gonna punch you in the mouth," well, that's not enough for the government to be able to regulate that speech. However, if I'm in the middle of swinging my fists, if I'm within fighting distance, now we're getting much closer to a disorderly conduct charge that will withstand the strict scrutiny of the court, because the fighting words have to be in conjunction with an ability to carry them out. Just saying, I want to punch Steven Crowder in the mouth on Twitter is not enough for the government to be able to regulate it. It might be enough for YouTube to regulate it, and I should add that I'm not saying those words, because I intend to do anything like that, YouTube, but that was an example. And while BL used vulgarity, her speech was not obscene, as this court has understood that term. So not obscene, which curse words are not obscene. Obscene is the more prurient interests. To the contrary, BL uttered the kind of pure speech to which, were she an adult, the First Amendment would provide strong protection. First Amendment protects even hurtful speech on public issues to ensure that we do not stifle public debate. The inappropriate character of a statement is irrelevant to the question, whether it deals with a matter of public concern. Consider, too, when, where, and how BL spoke. Her posts appeared outside of school hours from a location outside of school. She did not identify the school in her posts or target any member of the school community with her vulgar or abusive language. She also transmitted her speech through a personal cell phone to an audience consisting of her private circle of Snapchat friends. These features of her speech, while risking transmission to the school itself, nonetheless, for reasons we just explained, diminished the school's interest in punishing her utterance. But what about the school's interest? Here, primarily an interest in prohibiting students from using vulgar language to criticize a school team or its coaches, at least when that criticism might well be transmitted to other students, team members, coaches, and faculty. We can break that general interest into three parts. First, we consider the school's interest in teaching good manners and consequently in punishing the use of vulgar language aimed at part of the school community. See something 35, indicating that coaches removed BL from the cheer team because there was profanity in her snap and it was directed towards cheerleading. The strength of this anti-vulgarity interest is weakened considerably by the fact that BL spoke outside the school on her own time. See Morris, a U.S. Supreme Court case clarifying that although a school can regulate a student's use of innuendo in a speech given within the school, if the student delivered the same speech in a public forum outside of the school context, it would have been protected. And in Frazier, a concurring opinion, noting that if the student in Fraser had given the same speech outside of the school environment, he could not have been penalized simply because government officials considered his language to be inappropriate. BL spoke under circumstances where the school did not stand in loco parentis in the place of a parent, and there is no reason to believe BL's parents had delegated to school officials their own control of BL's behavior at the Cocoa Hut. Moreover, the vulgarity in BL's posts encompassed a message, an expression of BL's irritation with and criticism of the school and cheerleading communities. Further, the school has presented no evidence of any general effort to prevent students from using vulgarity outside the classroom. So it's not even equally applied. There's two different types of scrutiny for free speech, and you have the as applied and you have on its face. So if a law violates equality, not free speech, but the equal protection. If a law violates equal protection by the law being on its face a violation of some sort of equal protection standard, that's an on its face violation. If the law is applied differently, if the school applies it differently to one student than another, that's an as applied violation. So this would be an as applied violation, because there's no evidence in the record that the school applied this standard to other students, just to BL. Together, these facts convince us that the school's interest in teaching good manners is not sufficient in this case to overcome BL's interest in free expression. Second, the school argues that it was trying to prevent disruption, which is part of the Tinker Standard. If not within the classroom, then within the bounds of a school-sponsored extracurricular activity. But we can find no evidence in the record of the sort of substantial disruption of a school activity or a threatened harm to the rights of others that might justify the school's action. So no substantial disruption or no threatened harm to the rights of others, which was the Tinker Standard. Rather, the record shows that discussion of the matter took at most 5 to 10 minutes of an algebra class for just a couple days, and that some members of the cheerleading team were upset about the content of the Snapchats. But when one of BL's coaches was asked directly if she had any reason to think that this particular incident would disrupt class or school activities other than the fact that kids kept asking about it, she responded, no. As we said in Tinker, for the state in the person of school officials to justify prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. The alleged disturbance here does not meet Tinker's demanding standard. Third, the school presented some evidence that expresses, at least indirectly, a concern for team morale. One of the coaches testified that the school decided to suspend BL not because of any specific negative impact upon a particular member of the school community, but based on the fact that there was negativity put out there that could impact students in the school. There is little else, however, to suggest any serious decline in team morale, to the point where it could create a substantial interference in or disruption of the school's efforts to maintain team cohesion. As we have previously said, simple, undifferentiated fear or apprehension is not enough to overcome the right of freedom of expression. It might be tempting to dismiss BL's words as unworthy of the robust First Amendment protections discussed herein, but sometimes it is necessary to protect the superfluous in order to preserve the necessary. Oh, that's a great quote. But sometimes it is necessary to protect the superfluous in order to preserve the necessary. We cannot lose sight of the fact that, in what otherwise might seem a trifling and annoying instance of individual distasteful abuse of a privilege, these fundamental societal values are truly implicated. Although we do not agree with the reasoning of the Third Circuit panel's majority for the reasons expressed above resembling those of the panel's concurring opinion, we nonetheless agree that the school violated BL's First Amendment rights. The judgment of the Third Circuit is therefore affirmed. It is so ordered. And there you go. That really helps us understand exactly where the line is between school control over outside or off-campus speech. No, it really doesn't. So it's a little disappointing, but not unexpected. The Supreme Court of the United States doesn't like to project or rule broadly, more broadly than it has to. They like to find these narrow circumstances and define the rules narrowly. Sometimes that makes it very, very clear where the line between permissible and impermissible conduct is. Sometimes it does not. And this is a case where we can definitely say that things that are on the safe side of the line of this case of Mahoney High School versus BL. So we're just going to call this one Mahoney High School, I guess. Mahoney. Mahanoy. It sounds like it's a Native American name, Mahanoy. Maybe I should have looked that up first. But things that are on the safe side of this line, less than, criticism of non-school related things outside of school hours without using school equipment on the school website, those things are pretty safe. Things that are on this line, criticizing the school extracurricular programs, are probably safe so long as they're also outside of school and fairly privately done. Even publicly done is probably still safe. And then, if she had been in a remote learning environment when she said that, that's less safe. We don't know whether that is safe from school infringement or not, whether the school can limit the First Amendment protection in that circumstance yet. We don't know. This case does not answer whether the child who had a toy gun during remote learning during coronavirus, whether that violated that child's First Amendment rights. It sounds like the justices are ready to take that up when that case presents itself, but are hesitant to rule on it until they see that case actually before them. This also is consistent with the enumerated powers of the Constitution. I know it's sometimes weird when we go back to the Constitution and say, this is unconstitutional, but there is a very well-defined jurisdictional requirement in the U.S. Constitution that cases that go before the federal courts have to involve a live case or controversy. So if the Supreme Court rules too broadly, they're ruling on instances of facts that were not before them that are not a live case or controversy in this matter, that they were not pled, they were not argued, the parties weren't on notice about those situations, the amici and the parties did not brief the court, there was not testimony about that, so we didn't hear the whole story behind the student who had shown a toy gun on remote learning. So the justices are hesitant to rule broadly because those circumstances were not fully briefed and fleshed out for the case. But that's what we're left with. I kept calling it Mahoney. I guess it's Mahanoy Area High School. I don't know what they call it, but somebody can correct me in the chat, I'm sure. The dissent, someone wants to see the dissent. There is a dissent by Justice Thomas. It basically accuses the 8-member majority of not looking at 150 years of history supporting the coach. I hesitate to, I'm not, this is another 8 pages. I'm not going to go through it today because we're already half an hour into this. And nor did I read it, so nor am I prepared to speak about it, but I skimmed through it, and the Justice Thomas claims that there is a whole host of prior case law that could have been used to rule the other direction. But the fact that the other 8 members formed such a large majority, it's not a unanimous opinion, but 8-1 is still really strong. You've got justices that have opposing political viewpoints joining together to rule in favor of free speech. So there's no real argument that this is a political decision of any kind. This is a decision that is well within the ability of the court to make. It doesn't seem to me that it goes against 150 years of case law it seems to me pretty clear that the Tinker Standard was about whether the students' behavior created a real disturbance in the school, a substantial disturbance, or targeted the rights of others. And I don't see how criticizing the cheerleading team, even with vulgarity, creates a real disturbance in the school, even if it was on campus. But they didn't rule on that case because those weren't the facts before them. This happened outside of campus. It happened on private Snapchat. It happened with the person's 250 Snapchat friends. It wasn't published in the school newspaper. It wasn't posted on the school's message board. It wasn't during remote learning. So I don't see Justice Thomas's dissent as being a very strong dissent. But I've posted the document to my Patreon, patreon.com/ljfrench. You do not need to be a member to see the post and get a copy of the document. And of course the document's everywhere. I mean, you can just search for the case. You can just search for the F. Cheer case, and that'll pop up a million news articles about it. So you can definitely dig deeper. As I've said before, I am not here to tell you what to think. I'm here to tell you what to think about. So now if you're interested in more about this, you can read the opinion. It's not that long. The total opinion is 42 pages of the opinion and the concurrence and Thomas's dissent. Or if you just want to read Thomas's dissent, it looks like it's about 9 pages here. So that's all I have for you today. Thank you for joining me. I'm Leonard French, your favorite copyright attorney. And this is Lawful Masses. Please consider supporting us on patreon.com/ljfrench or sponsors.com/law, or you can join us on Floatplane or member us on YouTube. Special thanks to our supporters in the month of June. Our $50 plus supporters are Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, ShadowTycho, Earthbound Star, RDHDragon, and PureMagma. I love you all. I will see you in the videos that drop. Have a great week. Bye.